Travis Banks from the state defense. Dr. Bias on behalf of Richard Thomas, Your Honor.
Are both parties ready to proceed?
State is ready.
Defense?
Defense is ready, Your Honor.
All right, let's bring the,
Light stitch.
all right, thank you.
Sorry.
All right, everyone, please be seated. Defense, you may call your next witness.
Yes, Your Honor. The defense calls Richard Thomas.
All right, can you raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear you and the court reporter can hear you. All right, if you state your name for the record.
Richard Anthony Thomas.
All right, defense.
Thank you, Your Honor. Mr. Thomas, could you describe for the jury your relationship, if any, with Nina Sanchez?
As of right now, or
Let's back up a little bit.
okay,
Let's talk about when this allegation started.
my relationship with her, really didn't have one. I was kind of distant from her and Jacqueline.
Tell you what, let me ask you this. Were you strict on them?
Oh yes, yeah.
Why?
For one, that's the kind of parent that I am. But for two, I think I didn't want a relationship with them. I had left I separated from my wife, and I left my daughters and my son behind. And I think I kind of took it out on them.
So you're not surprised that Nina hates you?
Yeah, no, not at all.
I'm gonna switch it a little bit because I'm gonna get to the point. Did you do what Nina said that you did?
No, sir.
Did you touch her inappropriately?
No, sir.
Did you have a sexual relationship with her? Did you steal her virginity from her?
No, sir.
In fact, tell the members of the jury, how is it that you came about on giving this infamous confession?
I remember that they removed my children from the house. I believe I came home, my wife told me, or my wife called me. And I believe they spoke to my wife first, the CPS, and then they said if I would,
Objection, hearsay.
Overrule.
they said if I was willing to go in and give my statement. So I didn't have a problem with that. So I went in and talked to Miss Belinda. Right off the bat, she was very rude. She treated me like I was already guilty. I explained my side of the story. I told her none of that never happened. And obviously she didn't believe me.
And so to prove your truthfulness, you submitted to a polygraph test, is that correct?
Yeah, she recommended a polygraph test, and
Explain to the jury how that polygraph came about. What happened in there?
I know they asked me, I don't remember the questions, it was very long ago, but
Did they ask you to lie?
I believe so.
And so you had to lie.
I think, yeah,
And then they asked you whether you have lied in the interview.
correct.
And you told them,
No,
and so that's a lie.
correct.
That's the polygraph base of supposedly telling you that you failed this polygraph.
Yeah.
Were you truthful in this polygraph?
Yes, 100%.
And did you tell him at any time that you touched her, Nina, in any way?
No,
Well, then Mr. Martinez comes back and says, you failed the polygraph test.
correct.
May I approach, Your Honor?
Yes.
Now, we have what the state has introduced into evidence. The only piece of evidence introduced in this case. And voila, a polygraph test leads you to write that or sign that.
I signed it.
So you didn't say, hey, by the way, this is what I did. They told you what you did
Correct.
and you signed it.
Yes.
Please look at the members of the jury because they're deciding your fate. Why in the world would you do that?
Well, first of all, I was told that I failed the lie detector test, which I found out that wasn't correct. So I felt in order for me to get my children back, if nothing I said, that they would believe me.
So you signed that document
Correct.
under duress.
Yes, sir.
Now, Bruce, Your Honor,
Yes.
I noticed something very interesting in that document. Because when you submit a statement, all it requires is your signature, correct?
Correct.
Whose signature is right below yours?
Belinda.
Why would her signature need to be there?
Objection, speculation.
Sustained.
And then what would you have to have a witness?
Objection, speculation.
Sustained.
I tell you what. Was that statement what Nina recanted later on?
Yes, sir.
And so, which is why you were not charged.
Correct. They dropped the charges in the court.
So we know that she recanted something,
Yes.
and that's what they had against you.
Correct.
And approach, Your Honor.
Yes.
Here we are, fellow members of the jury. When was this statement taken?
In March 1st, 2007.
2007. How many years is that? Let's do this together. 2008, 2009, 10, 11, 12, 13, 14, 15, 16, 17, wait, 18, 19, 20, 21, 22, 23. How many years is that?
23.
No.
Oh, I'm sorry.
By the way,
16 years, I'm sorry.
do you graduate from high school?
No, I didn't.
Do you have a GED?
No, I don't.
Did you feel powerless in front of all these people? The detective,
Most definitely.
Belinda,
Well, yeah, because I've never been CPS. I'm
you have no education, correct?
correct.
You never had any occurrences with the law before.
No.
This is just the only time, and
Correct.
you felt trapped, didn't you?
Almost definitely.
16 years. Here we are. Why are you wanting to tell your side of the story to the jury?
Because I believe that there's more to
Objection, Your Honor, to what the defendant believes.
Overruled.
because there's a lot more to the story than just this confession
Nina tells stories, doesn't she?
all the time.
And most of them are pretty credible.
Objection, improper impeachment.
That'll be overruled.
Yes, she does many times, and I'm not the only one that she's ever said that touched her or
Now I want you to again look at the members of the jury and tell them, did you touch Nina in any way inappropriately?
no, I didn't.
Did you have sex with Nina any time?
Didn't.
Did you break her virginity to the point that she was bleeding in the sheets
No,
in your room? Did you ejaculate in that bed right next to her?
no,
Have you ever walked naked to grab her?
no,
Have you ever walked naked in front of your children
no.
with her?
Um,
Oh, Mr. Thomas, why are we here?
Because every time that I gave my side of the story, nobody ever believed me.
Here we are yet one more time. And may I approach your honor?
yes.
What the jury is gonna have in front of them is this. Why would you do that? Why would you confess to something that you didn't do?
Because when I told the truth, it didn't get me nowhere.
So now you lie and then your children are returned to you.
Correct.
Was that a relief?
How big we?
Let me ask you a question. In hindsight, would you have done it again if the state would have taken your kids?
Oh yes. I mean,
Why? I mean, here you are facing a jury of 12 people.
because at that time I wanted my children back. And I didn't know what was gonna happen next.
But if you didn't do it, why in the world would you say you did it?
Because every time that I told Belinda or I told anybody, it seemed like it didn't get me nowhere.
The investigator, did he ask you to collect sheets of this blood supposedly that was all over the place?
No,
Has anybody other than the polygraph asked you to submit to some kind of treatment?
no,
Mr. Thomas, 2007, you make a pseudo confession to get your kids back, and we're here. How does that make you feel?
Objection, relevance.
Overruled.
uh-huh. It's hard. Because I don't know. I don't know what would happen, what's gonna happen next. And it seems like every time I told my side, or I never shied away from CPS, I never shied away from the detective, always went in and gave my side, and time after time, it didn't get me nowhere.
You were the suspect from the very beginning, weren't you?
Yes,
And you were their target.
yes,
To this day, you're still their target.
correct,
Because now they're gonna show the jury that you confess.
Right.
You lied in that confession, didn't you?
yes,
In fact, that's not even your confession, that's Belinda's confession. Is that correct?
correct,
You just signed your name because you wanted your kids back.
correct. What was told by the one who conducted the lie detector test if I wanted my children back, that I have to be remorseful. I have to call Belinda and let her know that I want to confess. And,
Even though you did not do it.
and he told me that I have to be.
Objection to use, Your Honor.
Sustained.
Now, this is your chance, Mr. Thomas, to tell people that will bring finality to this case. These 12 individuals right here. I want you to look at them in their face, in their eyes, and tell them your side of the story.
I never touched Nina. I can understand why she hates me. I didn't treat her or Jacqueline the way a stepfather should have. And I did fail them in that part. Looking back at it now, I wish I could have. I wish I could have treated them better. But I was going through my own thing at that time, and it doesn't make it right. But with me and Jacqueline, I was able to patch that up with her. I've been in her life for 21 years. And
At this point, Your Honor, we're going to object to narrative.
Overruled. You can continue.
and I wish I had that same opportunity with him. But there's a lot more to the story that why she would run away, and it wasn't just the fact that
Objecting on response to the question.
That will be overruled.
it was the fact that yes, I was hard on her, but I would punish her for lying and stealing or doing things at school. She got older. She wanted to do certain things that I didn't approve of, having boyfriends or girlfriends. Or,
Objection under Rule 412, Your Honor.
Sustained.
Did you blame Nina?
blame Nina for it.
You here in front of a jury. Did you blame Nina?
Yes and no.
Explain that to them, because again,
I don't blame her because of how I treated her and her sister. But the thing is with Nina, she would always go over. And a lot of the things she would do.
let me make sure I get this straight, because the jury is listening. How you treated Nina, did that include sexually touching her?
No,
What do you mean by how you treated Nina?
just the way I was always on her. And every little thing that she did, I would punish her.
Is that why she hates you?
I'm pretty sure, yeah.
So I'm gonna ask you again, do you blame her?
No.
But the other side of that question is, was she truthful when she told the jury that you did whatever you did to her sexually?
Oh, no.
How can you ensure this jury that that's not what happened?
For many, many reasons. I was never alone with Nina. You know, that's not just something I would do.
Mr. Thomas, this is your chance to tell to the jury whether in fact you did what they say you did.
No, I didn't.
Again, how can you tell the jury?
Objection, it hasn't answered.
Overruled.
Because I never touched her. I never, also, there was never no evidence in me.
Madam President,
Yes.
I'm giving you the chance to convince the jury, but this is gonna go back there with,
Sidebar, Your Honor.
Sustained.
that.
Mm.
It says here that you touched her. Now tell them how you didn't touch her.
Well, I never touched her at all in any way and on this time and on any other time.
But that's your signature.
Correct. But like I said,
Objection, no question pending.
Overruled.
the reason why I did sign that was to get my children back.
I have no further questions from this witness, Your Honor.
State.
Mr. Thomas, you're telling that this jury today that you lied to CPS.
Correct.
You're telling this jury that you lied to the polygraph examiner.
Know that I told the truth. No,
That you told the truth to the polygraph.
correct, that I never touched her.
You're telling this jury that you signed that confession without reading it, without knowing anything that's on it. That's a yes or no question.
What was the question again?
Are you telling this jury that you signed that without knowing what you were confessing to?
No, I signed it knowing.
Okay, so you read that document before signing it, correct?
Correct,
You saw all the allegations that it made in there, correct?
correct,
And you still signed that document.
correct,
And you're telling this jury that that was a lie.
correct.
And you lied to get your children back. Is that correct?
That's part of it.
That's a yes or no question. You lied by signing that document to get your children back.
Correct.
So you lied to benefit yourself in that
To
that would
benefit,
help you get your children back.
to benefit my family, getting myself, to get my children back. Correct.
And you're telling this jury that now they should believe you even after you've already said to them that you would lie to benefit yourself. Yes or no?
Correct.
Now, you said that every time you've told your story, nobody believes you. Isn't that right?
Correct.
Isn't it possible that nobody believes you because you've already admitted to lying before?
Objection, Your Honor, argumentative.
Overruled.
That's a yes or no question.
What was the question again?
Isn't it possible that nobody believed you because you already lied in the past?
No, they didn't believe me because they didn't want to believe. They didn't give me a chance. CPS didn't do, she said she did an investigation. There was no investigation at all.
Well, didn't you sign a confession saying, admitting to touching Nina?
Correct.
And you're also saying here today that you got your children back right after you signed that confession, isn't that right? It's a yes or no question, sir. I'll rephrase the question. Didn't you just tell this jury that you signed that confession and then got your children back?
Yes,
But didn't Santa tell this same jury yesterday that it was months after you signed the confession?
Objection, Your Honor, so in fact not in evidence, be stated of the statements.
All right, so I'm gonna need you all to speak slowly so that the court reporter can write everything down. What is your objection?
So in fact not in evidence and misstatement of the evidence.
All right, that will be overruled.
Isn't it true that Santa told this same jury that it was months after you signed the confession
but you didn't
that
ask,
you were even back in the home?
you didn't ask if it was months. You just said if we got our children back.
My question to you now is, isn't it true that Santa told the jury that it was months after
I don't remember.
that you came back? Let me finish my question, sir, okay, please. Isn't it true that Santa told this jury that it was months after the confession that the children got back?
I believe so. I don't remember what she said.
And this case was still pending even after the children were back in the home. Isn't that correct?
No, we got our children back, it was closed.
Wasn't this case open for? Isn't it true that this case was still open in 2008?
I don't recall.
Weren't you arrested on this case in May of 2008?
Yes, that was the case that was dropped.
So you wouldn't have had contact with the children until after that case was closed.
Correct.
So you didn't get the children back right away. You didn't even have contact with the children until after the case.
I had contact with my son and my daughter.
But then you didn't get Nina returned, did you?
Her mother did. Her mother got Nina and Jack.
Mr. Thomas, if you know, who took the children from your home?
I don't know.
Would it surprise you to know that Santa, after being notified of your confession, took the children with her to her mother's house?
Sounds about right.
So nobody ever took the children from you. Santa took the children, isn't that correct?
No.
Isn't that what you just said?
No, I said they removed the kids. After the confession, we were able to get the children back.
You keep saying they removed the kids. Who removed the kids?
I believe it was CPS.
But you just said you didn't know.
I mean, I did know, but I didn't know who exactly. But I knew CPS had taken away the kids.
So then, when Ms. Castellanos testified to the jury that she has no power to remove the children from the home, she's lying?
Well, I don't know. I don't know her position on removing the kids or not. But I know my kids were removed from the house.
So she's saying that the children would not have been removed at the time of the investigation. That's a lie.
But what was the question again?
When Belinda Castellanos testified and said that the children would not have been removed at the time of her investigation, that's a lie.
That is a lie. Because the kids were removed from the house.
So basically, everybody else is lying except for you in this case.
Objection, Your Honor, argumentative.
Sustained.
Nothing further, Your Honor.
You know, perhaps you don't understand the term removed. The prosecutor is stating whether the state filed some kind of paperwork and then they were removed legally. But your children were taken from the house, is that correct?
Correct.
Is that what you mean by removed?
Yes.
So their children were not able to sleep in their beds at night for a while.
Correct.
Now, the prosecutor wanted you to show that, you know, Santa says next month.
Sidebar, Your Honor.
Sustained.
Isn't it true that Santa said 1 month?
I believe so.
I mean, you're under investigation. Are you stressed?
I'm very stressed.
Are you thinking whether it's a month, a day?
Not at all.
Your children were taken away and now they're brought back.
Correct.
When did that happen, sir?
When the children were removed,
Brought back.
to be honest, I don't remember.
Why would Santa have to take her children away from her house?
And that's what we don't understand.
And that's what you're referring to remove, right?
Correct.
Now, pros, Your Honor,
Yes.
it was only after she typed this and you signed, is that correct?
Correct.
Now your children are gone.
Yes.
Now, actually, they're gone. Now you submit this,
Yes.
and then a while back, they're brought back.
Correct.
But you just stated in 2008, you got arrested, correct?
Correct.
That's subsequent to that.
Yes.
Is that when Nina recanted her story?
Yes.
Why in the world are we here again?
I have no idea.
Nothing further from this witness, Your Honor.
So at the time that the children were removed from your home, where were they?
I believe they went with Santa's mom, I believe.
So they weren't in the foster home, is that correct?
No. Yeah, they,
So nobody from the state removed them.
all I know that they were removed from the house.
Where was Santa at the time?
I don't remember.
Was she able to see kids?
I believe so.
So she still had custody of the kids at the time. They just weren't living at home.
Correct.
Nothing further, Your Honor.
Nothing further, Judge.
All right, you may step down. Defense, call your next witness.
Your Honor, this time the defense rests.
All right, state.
State resting closed, Your Honor.
Defense, do you close?
Defense closed, Your Honor.
All right, ladies and gentlemen, I'm going to give you a break until 11 because there are some other things that we need to take up outside your presence. It's not involving this case. Remember the court's instructions that you're not to start deliberating internally with yourself or with each other. Everything that you need to know about this case is to come from inside this courtroom. Does everyone understand? All right, everyone, please rise for the jurors. Going to print out the proposed jury charge.
Your Honor, can I request that I get 2 copies so I can,
Oh, most definitely.
thank you, Your Honor.
Let me see. Is there anything specific that someone wants in the charge?
Just the honor about language, Your Honor, that's explained in the jury charge.
Your Honor, and if possible, if possible, an indication in relation to polygraph and the admission or inadmissibility of polygraph examinations. I think that's relevant because that statement indicates that he submitted himself to a polygraph.
Your Honor, the state would object to that as the door. I'm sorry, Your Honor. State
All right, so
does
here's the
objection.
thing. You all can discuss it amongst yourself with regards to the polygraph. My understanding that there was a hearing that was held suppressing the polygraph,
That is correct.
but then people entered statements with the polygraph in it, and people let witnesses testify to whether or not they took a polygraph test.
That's what I believe is imperative, that we have a paragraph explaining to the jurors the law on polygraph, Your Honor.
I understand what you're requesting, but the court's question is, why would you all have a hearing on whether or not the fact that someone took a polygraph is admissible or not? Then that previous judge, which I believe was Judge Angelini, ruled it was not admissible. And then everybody is entering documents with no objection to the fact that a polygraph was taken.
Again, Your Honor, you're correct. Judge Angelini ruled against the admissibility of the polygraph. However, that was contingent on the indictment. It was an attack on the indictment, therefore we should have been here, but he continued us to go to trial, even though this confession was obtained because of the polygraph. That was the gist of it, Your Honor. And so because of that, it's imperative that the jury hears the law on polygraph, because this confession was obtained simply because of a polygraph test, a tool that is inadmissible in court. And yet, here we are.
So it appears as though everyone went behind Judge Angelini's ruling.
Your Honor, the state would ask that.
Oh, we're just,
Judge, we
you
did
all,
not,
here's the thing. Mr. Bias, you all can formulate your arguments, state, you can formulate your arguments, then the court will hear it.
okay,
We're going to take a brief recess for us. The jury's going to be back at 11, but we'll be back at 10:45. Okay,
thank you, Your Honor.
you're welcome. You can mute us. All right. Defense, with regards to the jury charge, my understanding you wanted the presumption paragraph moved, so that will be moved, and you wanted it placed with the other paragraphs that state our law, so that's going to be changed.
As the court is aware, the court is the only entity that gives the law, and I don't see any paragraph that says our law provides.
All right,
all
all right,
persons
I'm
are-"
granting your motion on that.
Okay, thank you. Your Honor.
So now, with regards to the other issue, what is the other issue, counsel?
Is I believe that because the introduction of 2A, even though there was against the previous rulings, and again, the introduction was submitted by the state polygraph test, that I believe that the jury should hear the law on polygraph examination, and this is based on Tanner v. State 802 Southwest 2nd 678 633 Texas Criminal Court of Appeals in
You need to slow
1990.
down so that the court reporter can take it down.
I'm sorry.
So Tanner v. State, and what is the
80
side?
802 Southwest 2nd 678, 683 Texas Criminal Appeals 1990, in which the Court of Appeals or the Court of Criminal Appeals found that the court erred in admitting that any part of the testimony of polygraph examination, such as this confession. Then Netherly, this state 692 Southwest 2nd 686 700 Texas Criminal Appeals in 1985, where the court indicated that only could be admissible if the parties agrees. The defense is quite adamant in not agreeing with this polygraph test. That's why we submitted court hearings early on in the proceedings. Then in Fry v. United States, this is a Supreme Court case 293 F1013, in which the general acceptance doctrine that polygraph examinations are precluded from bringing into the trial. And so because of those case law and others, Your Honor, for time experience, I believe that the jury should be entitled to hear the law on polygraph examination, because Exhibit 2A speaks of polygraph examination. And if we don't explain the law, they're gonna presume that, well, it's a polygraph, it must be admissible. And that's where the confusion can be created, Your Honor, unless the court explains the law to the jurors. And for that reason, the defense believes that an inclusion of that paragraph of the law in relation to polygraph test should be part of the jury charge. Bless you.
All right, so defense, because I'm not the one who heard the motion to suppress, I just want to make sure that I have the sequence of events correct. The motions to suppress the polygraph examination was heard with Judge Angelini, is that correct?
That is correct.
All right, and Judge Angelini,
Your Honor.
excuse me,
There's a correction.
and Judge Angelini granted that motion, is that correct?
The motion to suppress the confession because of polygraph examination.
Okay.
The Judge Angelini did not grant that. He says confession comes in.
The confession comes in.
That's correct.
But not the polygraph.
Not the polygraph, which is why I didn't bring the polygraph nor the examiner. So that's the confusion, Your Honor. And so the
But
evidence.
counsel, did you not as in States Exhibit number 2. States Exhibit number 2, the mention of the word polygraph was redacted, correct?
That is correct.
And you asked that 2A be admitted, which would be
Unredacted.
unredacted. And that unredacted contained the fact that your client was alleged to have taken a polygraph.
And Your Honor, I believe you granted that on best evidence rule. That was my objection. You granted it and you said, okay,
Well, no. So that the record can be clear,
Mhm.
is you wanted the unredacted portion.
on the best.
I
evidence.
asked the state if they had any objections to the unredacted portion, and the state said no. So it wasn't the court ruling that
My
it should be
objection,
admitted.
my objection to the introduction was the best evidence rule. And so you went back to them, if you want to unredact it, and they say yes. And so, but I made an objection to the best evidence rule,
So you wanted the full,
everything.
you wanted the full document of 2A into evidence.
Correct.
And that full document contained the fact that your client is alleged to have taken a polygraph. Is that correct?
That is correct, Your Honor.
And the state had redacted out in State's Exhibit number 2 that a polygraph was taken, correct?
That's correct, Your Honor.
So now your complaint is you want the jury to know that a polygraph is not admissible.
I don't have a complaint, Your Honor. I believe that is in the pursuit of justice and fairness, the jury should be entitled to hear the law on polygraph examination. I'm not asking to tell them not to believe the document. They should hear the law on polygraph examination. That's it, Your Honor, because of the unredacted part of that confession.
All right. So that objection will be denied. Is there anything else from either side?
Nothing from the state, Your Honor.
All right.
So for the defense, Your Honor.
All right. So what we'll do is you each will have 15 minutes. I'm going to get the jury charge. And then I will give you all copies.
Thank you, Judge.
And does anyone want a time announcement?
If we can have a time announcement with 10 minutes left, Your Honor. Okay.
And who's doing the closing vote?
Yes.
And do you want a time announcement?
Just me, myself, and I, Your Honor.
No, I mean, do you want a time announcement?
2 minutes left.
Okay,
Thank you, Your Honor.
And Judge Fermine, can you let me know after 2 minutes has passed?
okay,
And I just open a trap door or something.
okay. All right. So,
Yeah, that's how I'm in the first place.
all right, then they will have that. So if y'all remain, they will give you the information.
All rise.
Oh, please be seated. Yes. It has to be here, right?
All right, for the jury?
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of the court. You do not have to memorize it. You will be given this copy back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Richard Thomas, stands charged in an indictment. I'm sorry, just one moment. Members of the jury, the defendant, Richard Thomas, stands charged in count 1 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 11th day of May 2006 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 23rd day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 3 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 25th day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 4 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 1st day of January 2012 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 5 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 1st day of February 2012 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of indecency with a child by sexual contact if, with the child younger than 17 years of age, and not the person's spouse, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 2, child means a person younger than 17 years of age. Spouse means a person who is legally married to another. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing, of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 3, our law provides that a person commits the offense of sexual assault of a child if the person intentionally or knowingly causes the penetration of the sexual organ of a child by any means. 4, our law provides that all persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 6, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There's no limitation period for the offense of sexual assault of a child and indecency with a child by sexual contact. Therefore, it is sufficient if the state proves that the offense as alleged in each count were committed sometime before May 19, 2021, which is the date of the indictment, the indictment was filed. 7, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 11th day of May 2006 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by touching part of the genitals of Nina Sanchez with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 1 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 8, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by causing Nina Sanchez to touch part of the genitals of Richard Thomas with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 9, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 3 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. 10, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 1st day of January 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 4 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 4. 11, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 1st day of February 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 5 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 5. In this case, there was evidence presented of more than one alleged instance that could constitute an offense committed by the defendant, if any. You are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense for purposes of each of the individual counts. You are to consider only that one act as alleged in the indictment by the state in deciding guilt or innocence on that particular count. Evidence of any other alleged act evidence of any other alleged acts is not to be considered unless you believe those acts were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child and the previous and subsequent relationship between the defendant and the child, if it does, and for no other purpose. You are also instructed that generally the results of polygraph tests are inadmissible in a criminal prosecution on behalf of the state or the defense. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter to communicate with anyone any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any role in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you are retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
May it please the court, opposing counsel, co-counsel, ladies and gentlemen of the jury. I'm going to go over a few technical matters with you, and then once I'm done, defense will have their time to talk, and Ruben will come after that and make further arguments. So let's start with the technical matters. We're talking about indecency with a child, and here are the elements. On or about some date anterior to the indictment, which is May 19th, 2021, in Bexar County, Texas, the defendant did intentionally or knowingly engage in sexual contact, touching the genitals, anus, or female breasts. It could be over or under the clothes with a child younger than 17 years of age with the intent to arouse or gratify the sexual desire of any person. Those are the elements that the state must prove beyond a reasonable doubt. And those are the elements that the state has proven beyond a reasonable doubt. You've heard from Nina, and you've also heard from the defendant in his confession. He confessed to doing all those things. I think the only thing that's not in the confession perhaps is that it was in Bexar County, Texas, and you heard from Nina, there's basically no dispute about where these accusations occur. So you have that with you in the jury, the confession, and I urge you to read it and understand exactly what he confessed. The other charge that you'll be deliberating on in the jury room is sexual assault of a child. And we're talking about on or about some date anterior to the indictment, same as the last one. In Bexar County, Texas, same as the last one. Defendant, same as the last one, intentionally or knowingly cause the penetration of the sexual organ, mouth, or anus of a child under 17 years of age. So it's a little bit different. And as you'll see in the indictment, the allegations are alleging this happened in a different time period. The indecency charges counts are earlier in time, and then later in time, there's the allegations of the sexual assault of a child. So one thing I don't want you guys to get hung up on
2 minutes.
is that first section about the jury has to agree that it's on the a date anterior to the date of the indictment. That's May 19th, 2021, as long as it's before that date. That's what's required by law. The legislature understood that the exact date might not always be known in these cases. And every instance that Nina talked about was before that date. And I want to remind you that you're the sole decider of the credibility of all the witnesses that were in front of you. Their testimony is evidence. So any testimony that you believed, you can consider in your deliberations. And the state's position is that Richard's relatives who came in to testify on his behalf were not credible witnesses. They all said that to the idea of whether you should lie for personal gain, they all said it depends. And I think if somebody has that kind of moral, they're not solid in their moral position on lying for personal gain, this is the exact situation where someone would come out and lie for personal gain. This is it, folks. This is when they would come and do that. And so I don't think you can trust them, and I don't think what they said was all that credible. They just seem to have a lot of it depends when asked about whether lying was an acceptable thing to do. And I also want to point out before I go that this is about Nina, and that she was abused by Richard Thomas, and the adults in her life failed her. And they failed her pretty badly. Her mother, the CPS workers, all allowed her to continue to get abused even after Richard admitted that he abused her. And defense said that in their opening that Richard has been waiting a long time for this, and I'll tell you, so has Nina. And don't fail Nina please find Richard guilty, and I reserve the rest of my time.
Spence?
Point of order.
Yes.
Councilors, ladies and gentlemen of the jury. I'm not here to tell you who to believe. That's up to you, entirely up to you. And for that, our founding fathers believed the system, and I believe the system. What I am going to ask you is to review that supposed confession. In the law was given by the court says here, notice, with the intent to arouse or gratify the sexual desire of any person. My client can even spell gratify. He has no degree. He couldn't have written that. That was given to him by Barbara. He signed to get his children. You know, I understand that all these allegations are serious. In fact, I told you, Nina needs help. Told you that from the very beginning. There's no question. This child has been hurt. This child, time and time and time again, continue to make allegations. This child has herself done what she's accusing my client of doing. You heard it. Again, I'm not telling you what to believe. Those are the facts. And the law does not require Richard to prove anything. He doesn't have to. But he wanted you to hear from him why he confessed. By the way, again, read it. It's verbatim. To arouse and gratify the sexual desire of a person. He has no clue what that means. Has no GED, has no high school. He's just a hardworking man looking for his family to provide and protect. And because a child that is troubled, make no mistake about it, she's troubled, makes these accusations, here we are once again. You heard the evidence say that she recanted. That means she changed her story. Wait, no, it didn't happen. This is when that statement that he signed in 2007, she recanted that. And yet here we are 16 years later. He couldn't even count. He said 23. 16 years, ladies and gentlemen of the jury. This thing has been going on for 16 years, accusation after accusation after accusation. Poor Nina. She is troubled. In her mind, she has created this fantasy that she's been having a relationship with her stepfather. She's perhaps jealous of the relationship with her mother. Troubled child. And the prosecution wants you to believe one sheet of paper. You're going to take it with you. One sheet of paper. A confession. He confessed. That's it. Makes you wonder what kind of system we are in which that type of behavior. Detective didn't question anyone. 1 hour he spent with her. Oh, she said she's telling the truth. 1 hour. Barbara, 1 hour. That's it. No investigation, no following up, no calling her schools, friends, classmates. Hey, is Nina telling the truth? We believe her. The judge just gave you the instruction that polygraphs are generally inadmissible. Read the letter. It was a result of a polygraph investigation in which the examiner makes you lie, then ask you on the examination, have you lied? No, because you're telling me to lie. Oh, there you are. You failed the polygraph test. Ladies and gentlemen of the jury, I suggest to you that if you have children taken away from you and you're dangling something in front of you that says, here, sign this and you got it. He say that he read it. I doubt it. In fact, I bet you if I make him read it, he wouldn't even know how to pronounce half of the words. This is difficult to do when you have people facing you, when you have prosecutors accusing you. You had the whole world saying you're just guilty. I get it. This type of cases, I get it. I'm asking you to do the honorable thing to do that I requested from each and every one of you. Stand firm. The prosecution has to prove to you. Not him. But yet here we did. We brought you, like Paul Harvey says, the rest of the story. Nina has issues. She said it. She's examining her sexuality since 14. She said it. I did it. This is hard. I get it. It's hard. I get it. But not creating an environment in which the whole family is affected by lies. Ladies and gentlemen, this has been time and time again dealt with by the court system. You heard he was in jail. And yet she recanted. Oh no, that's because mom forced her, because grandma forced her. That's the type of story that she creates. And when a person tells the lie time and time again, eventually you believe it. And the story gets bigger and bigger and more detailed. Guys, this is 16 years that she remembers to all this detail. And notice how the prosecution is asking you, oh, sometime between here and there. I asked my children, hey, do you remember that time that you ate that ice cream that you weren't supposed to? Oh, wait, I was 11, I was 12 or 13. No, I don't remember. You heard her. 10, 11, 12, 8. Guys, when things like this happen, remember. And the most compelling thing is when something like this happened to you, truly happened to you, you want to get revenge, don't you? You heard her. She doesn't want him to go to jail. It's a fantasy. Oh, she wants him to get registered. No, ladies and gentlemen of the jury, if something like this happened, throw the key and don't just, but it didn't happen. That's why she's giving you the ability to put him on probation. Just don't put him in jail. Ladies and gentlemen, see through the facade and notice how much, I allow him to talk and the prosecution was objecting, didn't let me ask many questions. I hope you notice that. Because when your case is based on a sheet of paper, I propose that is thin and is full of reasonable doubt. We don't have a definition. You get to say what is reasonable doubt, but question each and every instance. Question why the detective did not follow up. Question why Barbara had him say the same language the same verbatim. Ask why would anyone, if heard, will tell the perpetrator or the alleged perpetrator, that's okay, you can just be a register, don't go to jail. Only if this is a story in your head, a facade that you just want to, like a story, a love story. Oh, I believe she's in love with him for some reason. She needs help, ladies and gentlemen. But the court says, do not feel sympathy. You're not here because do not let, the court instructed, you are not to let bias, prejudice, sympathy. I feel sympathy for her. She needs help. But we cannot have that ruling based on that. I despise sexual predators. They need to be taken care of, but not honest men based on a paper-thin confession and based on a story that continues to be bigger and bigger. Ladies and gentlemen, she said that this story was recanted. She said it, not. Why are we here? Finally, please notice that confession, if you remember, the prosecution wanted to hide that paper, and we had a discussion, Exhibit 2 and 2A. It's the only exhibit you have, 2A. They wanted to redact that part about the polygraph. Oh, that's how it was obtained, through a polygraph. You are also instructed generally the results of a polygraph test are inadmissible, either for the criminal prosecution or the defense. This is why you didn't see the actual polygraph. It's inadmissible. Yet, that confession is because of it. Does that make sense? Only when a person feels so much empathy would a person believe a story as grand as Nina. I mean, she's having sex, losing her virginity, and she's standing up. I have girls, and I don't ask about those questions, but I know that there's some parts of their story that it just makes no sense. If at 14 she had blood and she had semen, why didn't she say, Mom, I've been telling you all these years, here it is. Go take that to the, never happened. It's the only plot. If you have the person that is abusing you, supposedly, now you have proof, oh well, it's not there. Again, she had the time to truly get this done. The investigators had the time, everybody. When the prosecutor says they failed, the system has failed, the state has failed, truly, because this case should have been dismissed. They knew this. They knew that she recanted her story. They knew that she's got some issues. They're expecting a juror of his peers to feel sorry for her. And make no mistake, I told you from the very beginning, she needs help. She needs help. But please, do what you said you were going to do. Stand firm for our founding fathers' values, that he is innocent until proven guilty. They have to prove him guilty. I believe that a piece of paper doesn't do it. That's the only thing you're gonna be able to take back. That's it. And you're gonna see that it matches exactly what the indictment says. Something that Richard could have never thought about saying, other than against his children. I understand that sounds very far-fetched, but that's what happened. The state, CPS, call it placement, removed them. Those children were not at their residence, period, where they're supposed to be sleeping at night. And for them to come back, I needed something from him. They got it. And here we are, 16 years later. Ladies and gentlemen, the jury,
2 minutes.
thank you, Your Honor. The credibility of each witness is up to you. The weight of the evidence is up to you. I'm gonna ask you when you go back to stand firm, just like the judge is asking you. Don't be persuaded, but you can change your opinion, but fight. If something inside of you telling you this is not right, fight. Do not give up because you want to go home Friday. Trust me, I want to go home, but I want this to be done properly. Now it's up to y'all to come up with a verdict. Find my client not guilty 5 times because the story, he is not guilty. You saw him. He told you this is in Nina's head. Find him not guilty. Thank you so very much. My client thanks you. The family thanks you. May God bless you and may God bless the United States of America.
Right, state.
Ladies and gentlemen of the jury, there's only one facade that's being pushed to you here today. And that's the facade that the defendant wants you to believe. He wants you to believe that he was coerced into a confession to sexually abusing one of the kids that was in his care, and that he was going to get his children back after admitting to sexually abusing one of them. Does that make sense to anybody in this courtroom other than the defendant? The defense is trying to confuse you with multiple different arguments about what could have happened. Why could Nina have done this? There's only one thing at issue in this case, and that's what the defendant did to Nina on 5 different occasions. You have the confession, which the defense is making a big point about. And I want you to remember one thing. That confession came from the defendant calling up Belinda Castellanos, asking her for a meeting so he can come in and confess. And Belinda told you he didn't write that, they wrote it, but they gave him every opportunity to read it, edit it for its truthfulness before he signed it, and signed in front of a witness as well. So consider that. You also heard Nina's testimony, and she has been consistent from the beginning. She told all of you that starting in 2006, there was only touching, which is corroborated by the defendant's own confession. Defense made a big deal about the dates and how she was still a virgin in 2006. Well, of course she was, because she's never told anybody anything different. The sexual abuse, the sexual penetration didn't start until 2011 after she turned 14. She told you all that, and that's corroborated by their own arguments. She was able to tell you that the first time she had sex with the defendant, when she lost her virginity, she was standing up. She remembered that detail. She told you in 2006, she remembers when he put his genitalia on her back, she felt it wet through her clothes. She remembered that detail. She has remembered details from each incident through 16 years that this has been going on. Her testimony is credible. None of her testimony has changed over the 16 years. And sure, she does have some flaws. She's not a perfect person, and she never claimed to be. She told you all upfront and honestly that she engaged in a relationship with the defendant when she was under the age of 17 years old. She admitted all of that. Why would she admit that if it wasn't true? Wouldn't it be more reasonable to believe that she was raped? And if she really wanted to make a lie and have people believe her, isn't that a little bit more believable? No, but she was honest with each and every one of you and told you that it was consensual. But again, remember, she's under the age of 17. She can't consent. But you know who should know right from wrong? The defendant. She admitted to running away. But what else would you expect from a child who's not protected by her parents? She's in a home where this abuse is being allowed to happen. What other choice does she have? And she admitted to not even being the perfect sister to Jacqueline. She admitted she harmed her physically. But the defense wants to throw out that she was sexually abusing Jacqueline. Where is the report? Where is any evidence that anything sexual happened between any of them other than Jacqueline's testimony? Who I will also remind you, as Travis told you, said that it depends whether or not you should lie in order to benefit yourself. You can't believe anything she said. And who has the motive to lie here? Does Nina? The defendant's not in her life anymore. She has no reason to get back at him. Her mom's not in her life anymore. She has no reason to get back at her. If she's trying to get him out of her life, he already is. You know who has the motive to lie here? The defendant. Because he's the one on trial here. He's the one that's facing time in prison. So of course he's gonna lie. And his own family told you that sure, it depends. Maybe you should lie when it's gonna benefit yourself. Each and every one of them told you that on the stand. But you know what they also said? They also said they wouldn't admit to a crime that they didn't do, which is what the defendant wants you to believe he did. He wants you to believe he never did this, but he admitted to it to get his children back. First of all, again, that makes no sense. How would you put children back in the care of someone who just admitted they sexually abused a child? You also heard from Belinda that nobody took the children away from them. Santa took the children to her mother's house to get away from the defendant after he admitted that he sexually abused Nina. Ladies and gentlemen, use your common sense when you evaluate that confession. Does the defendant's story make sense? Or does it make more sense that he did that and wanted to confess to it? Everybody's been talking about failures today. And yes, Nina's been failed by all of the adults in her life. She was failed by the defendant, her stepdad, who sexually abused her and manipulated her family against her to the point where none of them believe her and are on her side. She's failed by her mother, who failed to protect her from the sexual abuse and allowed her admitted, confessed sexual abuser back into the home. And that was before the sexual abuse, the sexual penetration even occurred. She was failed by CPS, who, under the wrong assumption that Santa was going to protect Nina, allowed Nina back into the home. And they didn't follow up to know whether or not the defendant was back in the home. I'm urging all of you to not be an additional step of failure in Nina's life. She told you that she's okay with him getting probation.
Yes, I'm gonna object improper jury commitment. And the closing argument, John.
All right, overrule.
They said she's okay with probation because, like I said, she has nothing to gain. The defendant's already out of her life. What's the difference to her if he's in prison or not? But you don't have to consider that at this point. What I'm asking you to do is find the defendant guilty on all 5 counts and hold him accountable for his actions, which is what Nina said that she's still here 16 years later to do, even though she gets no benefit from this. Thank you.
All right, ladies and gentlemen, I'm going to let you retire back to the jury room. I'm going to ask for Alonso and Sosa, if you could remain behind, please. Everyone, please rise for the jurors. Court is calling 2021 CR 4470, State of Texas versus Richard Thomas. Who have parties announced for the record for the state?
Ruben Rivera, trying to speak for the state.
Defense.
Dr. Bias, on behalf of the defendant, Richard Thomas.
Are you Mr. Thomas?
Yes.
All right, the deputy has informed the court that there is a verdict. There is to be no outburst from anyone. So please bear that in mind. If there is an outburst, then people are going to be excused from the courtroom. Does everyone understand? All right, let's bring them in.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you've reached a verdict in this matter. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you'll give the verdict form to the deputy, please. Thank you. Then will the defendant please rise? Count 1, we the jury find the defendant Richard Thomas not guilty of count 1. Count 2, we the jury find the defendant Richard Thomas not guilty of count 2. Count 3, we the jury find the defendant Richard Thomas not guilty of count 3. Count 4, we the jury find the defendant Richard Thomas not guilty of count 4. Count 5, we the jury find the defendant Richard Thomas not guilty of count 5. You may be seated. Would anyone wish to have the jury poll? All right, ladies and gentlemen, I'm going to send you back to the jury room and I will speak with you shortly, and then state or the defense counsel may wish to speak to you as well. All right, everyone, please rise.